Good day, everyone. Today we are diving into LEGO's intellectual property strategy, exploring how LEGO has built a formidable brand identity, secured not just by clever marketing but by a sophisticated multi-layered intellectual property strategy. By exploring three key aspects of IP, trademark, copyright, and patent protection, we'll see how LEGO has safeguarded its iconic status in a competitive global market. To illustrate this, we'll delve into few pivotal cases, each one spotlighting a different type of IP. Each IP category plays a unique role in reinforcing LEGO's market presence, from trademarking their distinctive branding to copyrighting creative designs like minifigures to securing patents that protect their unique engineering. Through this exploration, we'll show how LEGO's IP portfolio is a complex but powerful framework that protects their creative, functional, and brand-specific elements. Let's begin with trademark protection. Trademarks are a cornerstone of brand identity, safeguarding the qualities that make a brand recognizable and trusted. In LEGO's case, trademarks cover not only the logo but also the characteristic design, packaging, and even the bright colors that evoke an instantly identifiable look. Now, when we consider LEGO's brand presence globally, we are talking about a complex ecosystem of products that rely on consumer recognition and brand loyalty, something which Lepin threatened with near identical replicas. LEGO versus Lepin is an insightful case for examining the real-world implications of trademark law. Lepin was accused of replicating the look, feel, and even packaging of LEGO products, leading to potential confusion among consumers. In trademark law, this goes beyond direct competition. It introduces the risk of brand dilution, where the value of LEGO's brand identity is eroded by association with a lower quality product. Such dilution harms LEGO's position in the market, where its distinctive, high-quality brand image justifies premium pricing and long-standing customer loyalty. Trademark law, particularly under the doctrine of likelihood of confusion, works to prevent such scenarios. This doctrine asks courts to consider not only visual similarities but also marketing channels, audience demographics, and purchasing conditions. Through these factors, LEGO's legal team illustrated that Lepin's action created real risk of market confusion, potentially leading consumers to buy Lepin products thinking that they were LEGO. The doctrine of functionality also played a key role here. Functionality doctrine states that trademark protection cannot extend to product features essential to use. This limits brands from monopolizing functional elements that should remain accessible in the market. LEGO's legal team had to show that Lepin's imitation was not about functionality but about appropriating LEGO's distinct brand appearance. The balance here is crucial. While a brand like LEGO benefits from trademark protection for its identity, the doctrine prevents excessive control over universal building block features. And on the international level, LEGO's strategy exemplifies proactive trademark management. Leveraging global treaties like the Paris Convention and the Madrid Protocol, LEGO established trademarks in over 130 countries, aiming for global protection against unauthorized replication. This international strategy not only fortifies LEGO's market position, but sets a precedent for cross-border IP enforcement, a critical factor for any brand operating globally. LEGO versus Lepin teaches us how trademark law is more than just legal safeguard. It's a market strategy. It allows brands to cultivate a recognizable identity, maintain consumer trust, and protect their reputation. For LEGO, this case highlighted that trademarks are fundamental to sustaining its place as a top-tier trusted brand worldwide.
Let's shift to copyright, focusing on how LEGO uses this form of IP to protect its creativity under a functional product. LEGO's primary copyright concerns involve its storytelling elements, instruction manuals, and the unique designs of its minifigures. Unlike a trademark, copyright protects expression of creativity, works with sufficient originality that give them a unique artistic or literary value. The LEGO versus Bestlock case is an important case as it questions the boundary between artistic expression and functionality. Bestlock argued that minifigures were too utilitarian, lacking the originality needed for the copyright protection. LEGO responded that while these blocks themselves serve a functional purpose, the minifigure represent creative choices, a balance of design and aesthetic that is non-essential to the function of building with bricks. Copyright law hinges on the idea-expression dichotomy, which essentially separates unprotected ideas from protectable expressions. LEGO argued that Bestlock was not just copying functional block shapes, they were appropriating LEGO's creative expression, which was a direct affront to LEGO's market position. These minifigures are not mere toys, they're iconic representation that have become a part of Lego's experience. They carry the brand's identity into the hands of customers, enhancing the brand attachment and market exclusivity. This case also emphasized how copyright law can be applied to industrial designs that incorporate creative elements, as seen with Lego strategy. Copyright allows companies to extend legal protection over certain creative features that might not qualify for patent or trademark. This cross-functional use of IP laws help Lego secure a competitive advantage in the global market by preventing direct replicas of not only its branding but the actual look and feel of its product. Another international angle here is that the Lego copyright claims are strengthened by the treaties like the Berne Convention, which establishes that artistic and literary works are to be protected across borders. This allows Lego to take action against unauthorized reproduction in multiple jurisdictions, ensuring consistent market positioning worldwide. The takeaway here is that the copyright law, though typically associated with literature or music, can safeguard product features that are integral to brand's identity. Lego's use of copyright in the best law case underscores how IP protection serves a strategic role, preserving the brand's value in competitive, innovation-driven market.
Finally, let's examine patents focusing on Lego's interlocking brick system. Patents protect inventions by granting exclusive rights to creators for a limited period. In Lego's case, patents were initially granted for the unique structure of its bricks, which included the hollow tubes and interlocking mechanisms that made the blocks versatile and durable for building. But here is the catch. Unlike trademarks or copyrights, patents expire usually after 20 years. Once expired, the invention becomes public domain, open for competitors to use. In Lego versus Mega Bloks, Lego attempted to protect its bricks even after the expiration of the patent. Mega Bloks argued that the patent expiration allowed them to replicate the basic brick design. This brings us to the concept of patent exhaustion, which limits patent rights after sale or expiration. Under the law applicable at the time, comparable to the 20-year term in the Indian Patents Act, Mega Bloks was within its rights to produce similar bricks. The doctrine of functionality was also relevant here as patents cover functional inventions, unlike trademarks, which are restricted from covering functional features. Lego initially argued that Mega Bloks bricks went beyond simple functionality and tried to use other IP forms to sustain market exclusivity. However, the court ultimately found that once the patent expired, Lego's right to restrict similar products in the market ceased. This case highlights the broader economic implications of patents. Lego's monopoly on its block design was foundational to its early market dominance. However, once the patent expired, Lego had to adapt its strategy to maintain its competitive edge. The lesson here is that patents offer a temporary advantage after which innovation must take over. Lego's journey shows us how companies can evolve beyond patents, using other IP protections and market strategies to continue dominating a competitive landscape. In the global market, Lego's response to patent expiration involved diversifying into other IP protections, emphasizing brand loyalty, and launching unique collaborative product lines that distinguish it from competitors. The Lego versus Mega Bloks case exemplifies how patent law supports innovation while balancing the public's access to technology after a set period, fostering a dynamic industry landscape.
Through Lego's IP journey, we see how trademark, copyright, and patent laws are not only legal tools, but also strategic mechanisms for brand positioning in a competitive market. Each IP form reinforces Lego's business model. Trademarks secure brand identity, copyright safeguards creative elements, and patents incentivize technical innovation. Together, these protections help Lego maintain its status as a premium brand, adapt to market demands, and continue innovating. This layered approach showcases the critical role of IP law in balancing protection with market competition. Thank you for joining us in this exploration.